Thank you for joining us back here on Just Conspiracy. We really appreciate it. We're trying to make a change, bring heaven down to earth. Today, we're going to get to go back to the time when Baba and myself got arrested. This was right around the first time that I met Baba and Oracle. I just met them a couple of months before this. They asked me to come look at some things they had going on. I went over there and I said, yeah, this suit right here is complete BS. Nobody's saying anything. Nobody's verifying anything. Literally, nobody has accused you of anything. And here's what happened. Boyd Massagee, his father, represented Henry at the beginning of the trust fraud action. Boyd Massagee's father was the one who put in an equitable distribution complaint instead of an action for trust fraud. Now, Boyd Massagee Jr., he was coming after Henry. It was probably 3 years later, 4 years later, and his father had passed away. God rest his soul.
She was trying to, she almost threw me under the bus, so to speak, about that. And then Massagee gets his hand in with the judge, the last judge, that he wanted money that I owed his father who had passed away, rest his soul.
And he is suing on behalf of the law firm. He does not have any first-hand knowledge of the contract. He didn't witness Henry sign the contract. It wasn't a contract between him and Henry, him and Baba. But the important part of the contract was that Baba was paying them for good consideration and legal advice. Now, remember how on the last video I was talking about the trespass notices and showed some of the trespass notices? See, Oracle, Baba, and Loam, otherwise known as Gary, they actually all three got arrested for trespassing on their own property. Now, yes, it is as ridiculous as it sounds, which is why it all got dropped. But when they got arrested for trespassing on their own property, they got the legal advice that they could go back to the property and get their stuff from Massagee. And Massagee never stepped in and said, oh yeah, I told them that they could do that because they absolutely had the right to in law. So if you believe that that is good consideration, that renders fair and just compensation in the form of money, well, then I guess if we would have gotten this to a trial by jury, you probably would have been against them. But what happened? Henry already answered the interrogatories. That's how Massagee is moving for a summary judgment. And when I was talking to him, I said, you don't even understand these interrogatories. They're all legal questions. If you understood the answers to these questions, then why would you need an attorney? Kind of that simple. If you understood what legal documents were and what the legal process was, you wouldn't have needed an attorney. So you can't answer these legal questions in the interrogatories that are being asked. That's kind of the lead up to it. So, because Massagee had put in a false claim, and because Henry now knew what was going on, he sent Massagee a letter, a document, saying, hey, I don't believe you have a verified claim. In fact, I believe you're moving a false claim in the court. I hope you're not moving a false claim in the court, but if you have a verified claim, I'll settle with you right now. Right now. I'll pay you everything you do. All you gotta do is have that verified claim. And I guess Massagee thought it was a joke because he didn't answer it. And then Henry goes into court. And when he goes into court, he files 3 documents. 3. And that was, the first document was a document of recession. He was going to rescind his signature from all of the documents where he didn't know what he was doing, or he couldn't answer truthfully because he's not trained legally. And then the second document he filed was a file saying, hey, there is no attorney of record on the record. There's absolutely no attorney of record on this record for me. And he tried to get the clerk to certify that, which the clerk should certify what is and is not on the record, but they had a little run-in with me and they were told not to sign anything for me at all, ever. Because you just can't have somebody being able to prove you're not doing your job. And then the last thing he filed was final opportunity. He told Massey, you don't do this, then we're going to get to court and I'm going to declare you have a false claim. Move for what I get, fair and just in law, which they're lawyers and attorneys, they know. Somebody files a false claim against you, you get that judgment against them. That's the way it's supposed to be. This is the way you keep frivolous stuff out of court. Is because when a jury finds that the plaintiff was frivolous, he has to give up everything to the person he was going after. When the jury says, oh, whoa, what did you just do? You just committed fraud upon us. That's the way the law works. Nobody likes their time being wasted. I guess Massey thought that was a joke. They didn't think it was a joke because they were running around trying to convince Henry to just get up there and testify. And he wouldn't do it. And so we're going to start this audio off. Wait. Before we start the audio off, I got one thing to say. They're in there because Massey's moving a motion for summary judgment. And when I saw this motion, I told Oracle, I was like, this is what makes this guy a lawyer. The plaintiff moves the court that summary judgment be entered in the plaintiff's favor. For the reasons, this motion is that the pleadings, answers to interrogatories, and responses to requests for production and the attached affidavit show that there are no genuine issues as to my material fact, and the plaintiff is entitled to judgment as a matter of law. It's one of those, hey, I get this as a matter of law deals because we already have all the facts on the record. And he puts the certification right there at the bottom of the page, sending this off. And that's how an attorney writes. Short, sweet, simple. Now the first thing when we get in this audio, McAvoy Britton is going to talk about and verify his conflict of interest on the record. And just notice, if you watch the little clock thing from the clerk, the witness is stepping down and they never call Henry's case. They never call the case for Henry. They never do it.
Across the first bridge first. I was an employee of Prince, Youngblood, Maskey, and Jackson in 1988, I believe, until 1990, approximately, somewhere in that time frame, other than court or socially saying hello or whatever in the hallway. I've had no relationship to that firm in the intervening 20, however many years that's been, 28 or so years. But I have that prior relationship. Is there any objection from the defendant to my hearing this matter?
No, Your Honor.
I'll keep reading through the pleadings then.
So he announces his conflict of interest, and then he says that he has to review over the file. I don't know why, because it seems like they already had it worked out. I don't know what he has to review. I think he was thinking about whether he really, really wanted to go down this path of breaking the law or not. Because they didn't. They didn't want to uphold the law. They didn't wish to pay Baba what he rightfully deserved for having a false claim brought against him in the public. And from 27-26 until 39-29, McAvoy Britain is reviewing the file. Just like Fritz Mercer, I reviewed this file for 2 days. And this whole time, at least half this time, Loam and Baba are saying, JC, this is our case. This is our case. And I go, whoa, 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 whoa. Did they call your case? Did they call the case number? Did they say the names? All you see are 2 attorneys sitting before a judicial officer. When you 100% know that it's your case, say something about it. They're not supposed to do that. You gave them paperwork telling them not to do that. But maybe somebody else has that same attorney. Maybe it's somebody else's case. All you see are 2 attorneys talking before a judicial officer. That's it. That's all you see. And this is what happens when the case got started again.
Yes, sir. Mr. Maskey, anything further on your motion for summary judgment, sir?
Very briefly, Judge, you have our motion for summary judgment filed February 5th.
Judge,
It was
my name is
previously
Henry
noted-
Ramo.
Have a seat, sir.
That's my case they're talking
Have a
about.
seat.
And she is not my attorney of record.
Don't go ahead and have a seat.
She's not my attorney of record.
Have a
Tell him
seat,
now.
sir. You're going to
That's
be
my
removed
case.
from the courtroom. Have a seat. Mr. Sheriff, take Mr. Ramos, if that's his name, into custody.
Ramo,
The gentleman next to you, you going to have a seat, or you want to go with the sheriff also?
I hear you now. I hear what you're saying.
Mr. Sheriff, take both of them into custody.
What?
Sit over here for me, please.
Don't put those on me. I don't give you permission to touch me.
Sir,
Do not touch me. I don't give you permission to touch me. Do you know what you're doing?
yes, I do. If you step over here, please. Stand by right there. Step over here, sir. Heads up. All right. Place him in the box for now.
Excuse me?
I guess so, so they can, witness what's
Be
going
on.
on.
Both things you in custody. Come with me.
I ain't even say nothing. You might not have even noticed it. Did you notice him say, get that other guy back there too? I didn't even say nothing. At the end of Oracle's case, I said this.
We'll be back here at 2 o'clock tomorrow.
Yes, sir.
Tomorrow is,
Was it Tuesday or Wednesday?
yeah,
Thank you.
Wednesday.
I didn't even say nothing. Anyways, the plan was to get Henry and I out of there. They couldn't even trust Henry to get up and get on the witness stand and testify, because all he had to say was, I don't understand this legal stuff y'all are talking about that you're asking me questions about. All I know is that his legal advice got us arrested. And this is a false claim because nobody's verified anything. Boom! Got all the facts on the record to uphold a judgment for Henry. On Henry's behalf. So Henry would benefit. They couldn't have him say that. So they dragged an 87-year-old man out of court. And they took us downstairs. You know, in the drunk tank. It was real fun. And I'm going to prove to you in like a minute and a half how you know for a fact that they knew they were breaking the law, that they knew what they were doing. And it starts off like this. Right around 4609, Massey starts moving for a summary judgment again. Right around 2 minutes later, 48:10, I believe, somewhere about there, McAvoy has already given him judgment. He's already given them judgment.
Massey, I think I can pay attention to you while she's working.
Yes, Your Honor. Thank
If
you.
you want to proceed.
Thank you, Your Honor. This is our motion for summary judgment. We filed it February 5th, 2018. It's originally noticed for the 16th of March. There was an order continuing at Mr. Ramos' request to today in the matters timely before the court. The motion for summary judgment has supporting affidavits attached to it. The affidavits address specifically the employment agreement between the firm and Mr. Ramos. It identifies the amount owed. It confirms that no payment has been made, and it has, as I said, attached to it a copy of the agreement. There has been no affidavit or other opposing documentation filed pertaining to our motion for summary judgment, except for Mr. Ramos filed a document called Response to Plaintiff's Motion for Summary Judgment, which I noticed this morning is in the file. We respectfully submit, Judge, that this does not constitute an affidavit so as to resist a motion for summary judgment. I have a formal objection in the file for that purpose. I'll also hand up the 2 cases that are referred to that in that, Judge, if Your Honor will care for me to do so.
Yes, sir.
And we would ask Your Honor to enter judgment for the plaintiff, the amount of $8,215.50 plus interest as provided for in the agreement of 1.5% per annum compounded monthly plus costs.
Madam Clerk, the court has reviewed the pleadings in the court files. Based upon those pleadings, review of the motion filed by the plaintiff will find that the plaintiff is entitled to summary judgment and will so order.
May I approach?
I'm going to ask you to draft a different order.
I'll do so.
They had to have looked at Henry's paperwork. Not only did McAvoy Britton spend 12 minutes reviewing the entire file, but Massey, who we served those documents right there in the courtroom, brings up what Henry had filed and formally addresses it. Says, I hope the court doesn't use this against me.
There has been no affidavit or other opposing documentation filed pertaining to our motion for summary judgment, except for Mr. Ramos filed a document called Response to Plaintiff's Motion for Summary Judgment, which I noticed this morning is in the file. We respectfully submit, Judge, that this does not constitute an affidavit so as to resist a motion for summary judgment. I have a formal objection in the file for that purpose.
And you want to know how everybody knows that that was a bad judgment? Because he said, hey, I'm moving for a summary judgment, it had this attached affidavit, these interrogatories, all this stuff, but nobody verified anything upon the record of the court. And if you remember the last video, you're already going to know this clip I'm about to play, where a judicial officer and an attorney tell you the pieces of paper aren't facts upon a record of a court.
From people who she also stalked, harassed, and caused major fear and anxiety. And I'd like to call my witness with all the evidence I prepared for the past 2 weeks. I'd like to introduce the evidence and not just people talking. I'd like to introduce sworn affidavits from other people.
I'm not going to consider the affidavits, sir. Those are hearsay.
Your Honor,
He just doesn't know what to say to that. They are hearsay. Affidavits are statements where you say what you'd say if you were called in court, but you don't. They don't need to take them. You need to call the witness if you want to do that. But he's going nowhere. This judge is already done with him, and rightfully so. She knows that. She gave him his chance. He just wasn't making any sense.
You have to look at the videos that she makes. This is insane. You're listening to people who are putting on a good.
You want to know how else we know that they know what they're doing is completely fraudulent and against the law? Because Thomas McAvoy Britton says, if Henry comes back, I'm not going to feel comfortable upholding this. And of course, he's talking about the conflict of interest. And of course, Henry went back, but he wasn't talking about only the conflict of interest. He was talking about how McAvoy Britton committed fraud upon him by impersonating a judicial officer to issue an order for his arrest when he was interested in the case. And then, after that, he issued a fraudulent judgment order that was completely void, because a void order is not voidable. It's nothing you can take to the appellate court and have them void it. It's simply void. It should have no force or effect in law. Except in Henderson County, it seems to. Check it out.
I'm going to be a little concerned if he comes back later and wants me to set aside my judgment if he, as an individual now, opposes my hearing the matter based upon 28 years ago, not having been employed by the plaintiff in this matter. I'm going to go ahead and enter the judgment today. Well, I'm just, I guess, giving you a heads up that if he comes back and that issue is raised, I'm going to feel uncomfortable leaving this judgment in place if he raises that issue sometime in the reasonable future. Obviously, if it sits for time, then that concern is going to pass. But I do have that concern, and especially since he was not able to cooperate enough to sit in this hearing, and it's being entered without his being present, just letting you know ahead of time that I may feel compelled to readdress this at some time in the future.
That's how easy it is to show you that they violated the law. And these are the things that you have to know and understand before I start reading and explaining the federal suits to you, the viewer. Hopefully the individual who wishes to conspire to bring heaven down to earth. Hopefully the one who wishes to save rights and freedoms for their children and grandchildren. And you have to understand these things that have happened in the past, because after that, we wrote to every single appellate court justice and Supreme Court justice in the state of North Carolina, telling them what they were doing at that courthouse. We wrote to everybody saying, hey, we can't get anything done here because these tyrants are all conspiring together against us. And nothing happened. We went to go issue a warrant for Thomas McAvoy Britton's arrest, and he got promoted to Chief District Court Judge that same day. We got really good reason to believe he put in an order to prevent us from arresting him that morning. These are the things that you gotta understand. It's been a really, really long time. We haven't been able to find a court of law for like 4.5 years. And then, as soon as I feel like we have enough stuff to take it up to the big court because we predicted that they were going to violate our rights, throw Oracle in jail 24 to 48 hours before they did it, and we get thrown out of court because our facts are not actionable, I was so happy when the appellate court sent it back the same day, and then it was so disappointing getting those last papers. And I just wish to say this last part that I'm going to play, it's just going to be Henry. It's just going to be Henry and Thomas McAvoy Britton. I'm going to jump in a couple of times on a couple of key things that they say.
Mr. Ramo, are you able to hear me?
No, I guess,
Do you have difficulty hearing?
no, the acoustics down here are very bad.
Were you able to hear me when I was speaking to you when you were in the audience?
Not at all, no, except once when I returned the call to you and said, I don't understand what's going on.
Why did you not follow the directions of the sheriff?
I did after the second time you told me that's what I heard distinctly.
What I heard distinctly is I'm 87 years old, do not put your hands on me.
Correct.
That's not following the directions of the sheriff.
I don't want anyone to touch me, I didn't give him permission.
You understand, I told him to touch you.
You did.
I did.
I did not hear that. I
Because
don't
you
know why
were
you had permission to give him permission to stop me.
because you were disrupting court.
I was only answering against the attorney that was not my attorney there, but she's not representing me. And I had to voice my own willingness to say that she is not my attorney.
There's a
Why did you
proper,
do?
there's a proper way to do that and an improper way to do that. The way you did that this morning was not proper.
I'm not an attorney.
There is a proper way and an improper way that you inform the court that that woman wasn't your attorney. You did it the improper way. How? By filing and giving you written notice? Putting it in the file you reviewed for 12 minutes? So frustrating.
It was not proper.
I'm not an attorney, so I don't know.
You're acting as your own attorney. You're deemed to know the rules. You understand that going forward?
But what you're telling me now, I have to know the rules?
Absolutely.
Oh,
The
how
law
do I
is-
learn the rules, sir?
The law assumes you know the rules since you are choosing to act as your own attorney.
Never said I was my own attorney.
Well, you don't have an attorney, you're acting as your own.
Well, I was not acting as my own. If you say so, I was not. I'm not claiming as an attorney. I never had experience to be an attorney. So don't, sir, don't say that I am acting as an attorney when I don't know. I
Sir,
don't know the law.
I'm trying very hard to avoid sending you to jail.
Okay.
You understand that?
You are acting as your own attorney. Why do they put so much emphasis on this? Why do they have to say you are acting as your own attorney? You are representing yourself? Representation of persons in law is a fiction. And if you're a fiction, then they can do whatever they want to you, and it's not wrong, because you always got to have the bad guys in the fictional roles. But when you're real, when you're living, when you're in the world of man and woman, not attorneys, you're not in the world of being handed over to another God, then I guess Lord State God, you got to do everything that that individual tells you. And if you want to say that the court had jurisdiction, let me ask you something. What gives the court the jurisdiction to arrest Henry just because somebody filed an action against him? Like, where did they get that jurisdiction to arrest him? That's absolutely insane. But listen, McAvoy tries to convince Henry he is an attorney like 3 times, and then he finally gives up. Why is it so important? How do you represent myself? I don't know. I'm just here. I'm just present. Why can't I do that at court?
I hear you right now.
This is not a debate. I am trained in the law. I do know what the law is, and I know what the law presumes. And I don't appreciate you questioning that. I appreciate even less you not obeying the directions of the sheriff in court when he is telling you something to do. If the sheriff comes to you at my directions and tells you to do something, you're to obey that. You may not like it, you're to obey it.
Ooh. This is the type of thing that it's just like, am I a slave? Don't ask that question at court. I've seen people get arrested for it. Witnessed with my own eyes. I'm to obey you? I'm to obey you. I have no more free will. What gives them that kind of power? Why do they have that type of authority over you, especially when somebody else is bringing a false claim against you in a court? You're to obey me.
Do you understand that, sir?
I understand it, but I didn't hear you for the first time.
All right.
That's what he had to tell me. This gentleman here.
Yes, sir. I don't know if we'll share a courtroom again or not. If we do, I expect you to be orderly. If a sheriff comes to you and says do something, I expect you to do it.
That's what he do.
If the sheriff is out of line and telling you to do something, that's between me and the sheriff. When you're in a courtroom, that's not between you and the sheriff. You understand that?
Present, yes.
Well, do you understand it going forward? Because that's what's most important to me. I don't want you to forget it when you walk out the door and us have this issue again.
Well, sir, once I hear your orders distinctly, I will listen to them.
Mr. Sheriff, you may be released at this time.
Henry got let go. They kept me for about 48 hours. Pretty crazy. Being arrested and held for 48 hours for helping an 87-year-old man stand up. Absolutely ridiculous. You know, the other day I was watching on YouTube one of those First Amendment auditors, and they were out in front of a public square saying, "God bless the homeless vets." Wow. I think if we could just get to the point of restoring Henry's home to him, we'd be making progress. If we just allowed the vets to have the homes that they worked for, that would be an improvement right now. And this is why I'm making these videos, is because we have to understand as a society, we have to understand what the very basic and simple rules of law are. Like somebody having to verify something for the record. Because any judicial officer would understand, any attorney would understand, but the general people do not understand. And this is the way that they typically do whatever they want to do when they're committing some type of atrocious wrongdoing at court, is they have to do one of two things. They either got to beat up whoever can verify something that they don't wish for it to be on the record, or like they did in August, they let Henry stay in there because Josephine was already telling a story, and the judicial officer could just be like, "I just believe her story, I don't believe your story," which is the whole reason why we have trial by jury here in America, where we don't trust government. And this is why you should not trust government, because even listen to Thomas McAvoy Britton. He says it. He goes, as time goes on, I'm going to feel more and more comfortable about doing this. And that was 4.5 years ago. I bet he feels really comfortable right about now. I bet they feel so comfortable with breaking the law and like the public just won't do anything about it, that they'll even bring in Henry, arrest his daughter, beat her up, throw her in jail because she could put facts on the record that would be undisputable, especially in a way that's undisputable. I'm sure that they knew she knew how to do that. So they had to beat her up, get her out of there so that they could rob Henry. And what happened back in 2018 with Massey? It's like, well, that's kind of a hard sell to people because it was an attorney going after him. Even if people kind of thought or saw the fraud that happened, saw how absolutely atrocious and lawless it was, for some reason here in America, we just kind of accept that over there in the legal society, sometimes they just look out for each other and they break the law and there's nothing you can do about it. But at least Massey was a member of the legal society. It was somewhat kind of understandable. Thomas McAvoy Britton used to work for him. He announced his conflict of interest in open court. What did you think was going to happen? But now, today, they feel so comfortable with just controlling every aspect of law that they're willing to beat up Joni because she has an interest in the case and what's going on, and they can't let her get her facts on the record. And they help Josephine rob Henry. They help Josephine rob Henry. Josephine's not their buddy. They're stepping into the middle of personal and private relationships and breaking the law, helping the lawbreaker break the law. 4.5 years later, I guess they're not concerned about it anymore. And it's not like courts haven't gotten this way historically. We know of times that courts have gotten this bad historically. One of those times would be right around 1215. And what the people did is they got together and they wrote a document called the Magna Carta. And anybody in the legal profession that knows anything about your rights knows that that's kind of the document that helped start the whole idea of secured rights by the government. At least in common law countries. It was the whole idea of why we created a constitution, was the Magna Carta. And that's another example when courts got this belligerently lawless. They did that in the colonies, and the king would transport people over to England to try them because he'd get a different jury over there. That's exactly why when we wrote our constitutions, we said, hey, here's where the jury will come from. Come from that district. It will come from that area. In 2018, the state portrays violence against me and Henry so that an attorney could get a judgment, a summary judgment against Henry. That's absolutely void of any law. And in 2022, they're willing to beat up an interested party in a case, throw them in a jail, just to make sure that nothing that looks like truth gets on the record of a court. That's a pretty scary progression. And in the middle of that, I witnessed a man get arrested for asking if he was a slave in open court. That is a very, very scary progression. It's not that your rights are going to be gone tomorrow. It's that your rights are already gone. And if you've been fortunate enough to not experience that yet, that's just because they're so backed up, they're so good at administration that their administration is backed up and they just haven't gotten the chance to get to you yet. That's all that is. And that's why over here, we are just conspiracy and we just wish to conspire to bring heaven down to earth. And if you're not conspiring to bring heaven down to earth, you're kind of conspiring to bring hell up here. even if it's not a conscious choice, even if you're not actively doing it. So please pay attention to what you put your energy towards. And the whole way, the whole motivation, the whole goal of bringing heaven down to earth is through law, is through courts of law where a civil society can be civil with each other because rights and justice are upheld the way they should be. And if we can't get this, if we can't get rights and justice, and we lose those things, they will be gone forever. The state of the surveillance state is such, if we lose rights and justice, there will never be able to grow pockets of people with different thought to challenge the establishment that took all of the rights and all of the justice away from us. One world, love, and peace.
Yes, sir, Mr. Maskey, anything further on your motion for summary judgment, sir?
Very briefly, Judge, you have our motion for summary judgment filed February 5th.
Judge,
It was
my name is
previously
Henry
admitted-
Ramo.
Have a seat, sir.
That's my case they're talking
Have a
about,
seat.
and she is not my attorney of record.
Y'all go ahead and have a seat.
She's not my attorney of record.
Have a
Tell him
seat,
now,
sir. You're going to
that's my
be removed
case.
from the courtroom.
Have a seat.
Have a seat.
Judge says have a seat.
Mr. Sheriff, take Mr. Ramos, if that's his name, into custody.
Ramo,
The gentleman next to you, you going to have a seat, or you want to go with the sheriff also?
I hear you now. I hear what you're saying.
Mr. Sheriff, take both of them into custody.
What?
Sit over here for me, please. Place your hands back.
Don't put those on me. I don't give you permission to touch me.
Sir.
Do not touch me. I don't give you permission to touch me. Do you know what you're doing?
Yeah.
Yes, I do. If you step over here, please. Stand by right there. Step over here, sir. Heads up. All right. Place him in the box for now.
Excuse me?
I guess so, so they can, witness what's being on.
Both of these in custody.
Complete.